In this video, we will introduce the parol evidence rule. In general, the parol evidence rule provides that once a written contract's terms are finalized, evidence from outside the contract is prohibited for purposes of changing the terms of the contract. More specifically, the parol evidence rule applies to so-called integrated written contracts, that is, finalized terms in a written contract. The rule excludes outside or extrinsic evidence, such as prior negotiations or discussions that would be used to contradict or change the finalized terms of the contract. But keep in mind that evidence from outside the contract might be admissible for purposes other than contradicting or changing the terms of the contract. Contracts are often negotiated over time, and the parties might discuss all sorts of terms and conditions, such as payment terms, relevant dates, and each side might have different views as to what should be agreed on in the final contract. At some point, though, we hope the parties will reach an agreement, and they'll sign a contract with final terms on which all parties have agreed. Now, if this is an integrated contract, meaning it has all the final terms on which the parties have agreed, then the parol evidence rule will exclude evidence that would change or contradict the terms of their contract. So, for example, if an integrated contract provides a payment term of $25,000, one party couldn't try to introduce evidence that there was an earlier agreement in which the parties really decided that the price should just be $20,000. Because the $20,000 term would contradict the $25,000 term as provided in the contract, it would be excluded by the parol evidence rule. A party would not be allowed to introduce as evidence that during negotiations the parties agreed on $20,000 because the integrated contract provides that the payment is $25,000. There are limits to what the parol evidence rule excludes. For example, if one party fails to pay as required under the contract, of course, evidence of this failure to pay could be introduced into evidence. Likewise, if there is a term in a contract that might be ambiguous, such as the usual shipping terms, and we can't say for sure what those usual terms are, the parol evidence rule will not exclude evidence to explain that ambiguous term. Outside evidence might be allowed in to explain what the parties meant when they agreed on the usual shipping terms. Perhaps that refers to transport by truck, insured by one party or another. To summarize, the parol evidence rule applies to integrated written contracts, contracts with finalized terms. The rule excludes extrinsic or outside evidence, such as evidence from negotiations or even prior agreements that would be used to contradict or change the terms of the contract. The rule does not exclude evidence for other purposes, such as evidence to prove that a party failed to provide the consideration that it promised, or evidence for purposes of explaining ambiguous terms within the contract.